We'll start when my computer says it's 9 o'clock, and it hasn't said that yet. All right, it is 10 a.m. I am going to call this meeting to order. This is the June 17th hearing of the Klickitat County Hearing Examiner. My name is Andy Kotkamp, and I've been appointed by Klickitat County Board of Commissioners to serve as a land use hearing examiner. We are here on two matters: a SEPA appeal given application number 2020-21 and a conditional use permit application 2020-13. We were set to begin the SEPA hearing this morning. I would note that yesterday afternoon I received a letter from the appellants, which I consider to be a motion to disqualify the hearing examiner for the reasons stated within that letter. Although it's characterized as an objection, I think a fair reading of that is a motion for the hearing examiner to be removed. So, as I indicated in my email to you yesterday, we did have some email exchanges going through. I received this letter at 1:16, and then there was a brief response by myself. We did have responses that came through from the applicants and from the county. I understand both of those positions, but I don't see any other alternative, and because the bell's been rung, quite frankly. And so this motion to disqualify the hearing examiner, if recharacterized by the appellants, it certainly could be brought by any member of the public. And so we need to resolve this issue before we continue on.
Mr. Kotkamp, will you allow me to jump in here, because we'd like to have a discussion about whether or not it would be better to proceed with the hearings today and tomorrow as scheduled.
You can, if you want to make a record. I understand everybody was ready, but I am going to continue the hearings. So if you want to make a record for whatever purpose, I'll let you make that record, but I am going to continue these hearings on a very short basis so that we can resolve this issue and move forward with it without having this cloud over us as to having an extra appeal issue, which may require us to come right back to the start from page one. So, well,
if you'll allow me, I think everybody's ready. I think that we realize that this issue may result in a basis for an appeal if you proceed and have the hearings, but we think that frankly there's a risk of deferring this and going through motion, argument, and briefing and so forth, and then having a decision rendered 6 weeks from now that could still result in an appeal on the same basis. We just think that if you delay this and go through all of that, then we will have spent the time to get ready and be prepared and have our witnesses ready. And the same for the appellants, frankly. So we believe it'd be best for all parties to proceed with the hearings today and tomorrow as scheduled. The cost in time and money of getting to this point to hold the hearings now far outweighs, I think, the cost of having 2 more days of hearings only to subject your decision on the hearings to the risk of appeal, or of using the time today and tomorrow. So the county has the authority to have made the decision on the authority of the appointment of a hearing examiner in your authority. They made that decision. There appears to be ambiguity in the county code. For example, the code doesn't authorize the Board of Adjustment to hear a SEPA appeal hearing. But so there may be ambiguity, and maybe that this will all result in an appeal, but we're already, also the Board of County Commissioners has 2 of 3 commissioners who have stated they were conflicted, so they may not even be able to constitute a quorum if they were to hear the appeal on SEPA. So we just believe that there are issues that may get argued. Mr. Telligent, if he wants to challenge your authority, should have filed an action in Superior Court. But the county has the decision-making authority, and they made the decision to appoint you as a hearing examiner. And so we just think the risk is far greater to defer this while we argue whether or not you have the authority as a hearing examiner, and lose the time and readiness that we already have. So we think the best course of action is to proceed with these hearings immediately, because we're ready and we're willing to take the risk of an appeal if the hearings are held today and tomorrow, and then you make a decision and then that gets appealed.
All right, thank you very much. Does anybody, I am going to continue this matter. I appreciate that, Mr. Cassina, but it will be a short continuance, and there are going to be some stipulations attached to my order of continuance when we get to that point. But did anybody else want to put anything on the record for either the county or the appellants?
Mr. Cockamp, I understand the position that you've enunciated pretty clearly in the email you sent yesterday, and again this morning, so won't belabor the point. I do agree with the sentiment that we should proceed. Your pre-hearing scheduling order mandated all pre-hearing motions to be filed by April 1st, 2021. That is months ago. So to get such a motion, again, the tactics of litigation by ambush seem to be foremost in the appellant's strategy for the incredible cost and delay. It's untoward. There's no doubt the Board of Commissioners have the ability to appoint a hearing examiner to hear the SEPA appeal. There's also little doubt that it's appropriate to consolidate the conditional use and the SEPA appeal before the same body to avoid redundant or duplicative efforts and costs. So, you know, there was ample time to bring this issue to the hearings examiner. There was ample time to seek injunctive relief in a court. This is just a strategy to delay, to continue the pattern of harassment and intimidation of the planning department, the Board of Commissioners that that have been undertaken here. So I believe there should be a consequence for the late filing of this motion. We ultimately believe would be without merit. There's going to be an appeal issue no matter what your decision is, hearings examiner. There's going to be a winner and a loser based on your decision, and I don't think anyone that's participating in this hearing or litigation anticipates there won't be an appeal by the aggrieved party. So that's the county's position.
Thank you very much, Mr. Cannell. And one of the things that I have been struggling with and been doing some quick research in is an issue that I don't know if I brought it up in my email response about whether there has been any waiver, but the issue from a hearing examiner standpoint is I don't believe I have any jurisdiction in matters of equity, estoppel or waiver or latches or things of that nature. So that's something that I'll have ask the parties to brief when we get to that point. But I am, well, before I move on, is there anything from the appellants?
This is Mr. Telligent for the appellants. First, Mr. Quesnell referenced an email you sent this morning. I did not receive that.
I think he's probably was talking about the one that I sent late yesterday afternoon that he may have just seen today. I did not send an email out this morning.
Thank you. Then I have nothing further except for I'm not sure what intimidation or harassment he's referring to.
All right, well, we're not going to go there. Okay, so here's what I'm going to do. I asked everybody to have their schedules out. This will have a priority setting. I'm really not going to be interested in my experts not available. The experts have all had opportunities to submit lengthy reports, and so I'm not too concerned about the expert not being available to testify. But in any event, we're going to start with the hearing, and then I'll move backwards from the hearing. So the hearing on this motion, I'm proposing either July 14th, 15th, or 16th. Mr. Telligin, do you have any objection to any of those dates?
Just one second. You said July 14th, 15th, or 16th?
Correct.
I am out on the 15th and the 16th.
Mr. Casino or Mr. McDonald, are you available on the 14th?
Yeah, this is Mr.
Yes, sir, I am.
And I'm also available on the 14th, 15th, and 16th.
All right, Mr. Cannell, is somebody from the prosecutor's office available on the 14th?
On the 14th, we can make ourselves available, yes.
Thank you very much. So I am going to set the motion hearing. Let me get my calendar up for July 14th. And we are going to set this for 3 p.m. I'm going to ask that the county and the applicant have any responsive materials that they want to send to me be filed by 5 p.m. on July 7th. And then any reply from the moving party by July 12th. And now we'll move to the matter of the hearing. I have several dates. Most of them are consecutive. The first two dates that I'm considering, let me make sure about this, is the 22nd and the 23rd of July. Once again, and then I would, then we'll work from that. But are the 22nd and 23rd available for the applicant?
Your Honor,
What is,
go ahead, Jim.
what is that on the 22nd?
The 22nd and 23rd would be new dates for the hearing. If the hearing examiner denies the the appellant's motion, then we're going to have the hearing. And I'm proposing, I want to set those dates today. So we're talking about, to start with, the 22nd and 23rd of July. I realize that we're having the hearing on the 14th. I would have my decision made before the end of that week. And then we would have the hearing start on the 22nd and 23rd, if that's what my ruling allows. So
Are you expecting that the hearing will be via Zoom?
yes.
As was, yeah.
Mr. Kockamp, this is Tom McDonald. Obviously, it's a summer schedule, and we'll be missing witnesses that we had planned for today on the 22nd and 23rd. So it would be helpful to know what your ruling would be in regard to expert witnesses. Are they, they have to be available for, like, if we want to cross-examine the appellant's expert witnesses after they file their replies? Can we and some of our lay witnesses go ahead and file just written testimony from them if they're not available? I know that the appellants have done that themselves. They filed declarations on their lay witnesses. So it would help me to understand whether those dates are really reasonable. I'm available, but are they really reasonable for us to put on our case? And so if you could maybe talk a little bit more about what you think the limitations will be, or the on the witnesses or the opportunities. We agree that there shouldn't be any more expert statements filed. We agree that in the hearing, if the witnesses are called, they should be limited to what they have provided in their written testimony in terms of opinions and the basis for those opinions. So I think the hearing can go efficiently.
Although I would, you know, I would want the opportunity to cross-examine since the appellants got the last reply. But in any case, if you wouldn't mind, what were your thoughts in terms of witnesses, allowed, not allowed, that type of thing, if you have any?
So my initial thought on that, just so everybody knows, is that we would basically just be picking up and moving today and moving it to the 22nd or whatever starting date that we have for the combined hearing, assuming that we get to that point. There's not going to be any additional briefing. There's not going to be any new expert opinions. There's not going to be any new public comments allowed. There's no new witnesses, of course. I think it's reasonable that if a witness is not going to be present at the hearing, that you can rely upon that witness's expert report at this point, because there have been a reply and there hasn't been an opportunity for the applicant to respond to those replies, and they may not have an opportunity for cross-examination. Then if a witness isn't going to be called live by the appellant, then the exception to the no new reports would be that I would allow the applicant an opportunity to submit, if you will, a surrebuttal to the reply, instead of having an opportunity for cross-examination if that witness is not available to testify. So those are my thoughts on that. Let me see here.
With that said, would you be able to, I don't mean to get ahead of you on this, but will you issue an order that we have to know from the appellants which expert witnesses they are going to call? And so we have time to understand whether we're going to have to do a rebuttal or we'll have the opportunity at the hearing. And can we file declarations from our lay witnesses that will not be available?
Since lay witnesses are not subject to cross-examination, if the lay witness is not going to testify, they can certainly file a declaration. And that would be the same for the appellants as well as for the applicants. If somebody is not able to testify that's on your witness list, that a declaration could be filed in that stead. Okay.
Thank you. And
I think it's reasonable that we set a time limit, Mr. McDonald, for the appellants and for that matter, the applicants to determine whether or not what witnesses are going to be called live and what witnesses are you just going to rely upon their reports. So I don't have any issue with that.
okay,
That seems to be a new rule. I think we had said at the pre-hearing conference that as the appellants, we would get the last word, and then if witnesses were going to.
We're in a different time zone now. So you've had your reply, and if the applicants are not able to do a cross-examination, then they will be allowed to do, like I say, a surrebuttal, if you will, of the reply from the applicants or from the appellants.
thank you, Your Honor.
So let's go back to the 22nd and 23rd. Do those dates work?
They work for the appellant.
Thank you.
Your Honor, they don't work for me
Why not?
because I have another engagement those days.
Is it a work engagement?
Yes, it is.
All right, well, we'll come back to that possibly. Like I said, this is to be given a priority. This is all being brought upon because of the appellant's motion, and I do want to have this matter heard sooner rather than later. I do have some other proposed dates, so I'll go through those. But like I said, you need to be thinking about whether or not you can move other items so that we can have this hearing. Okay? July 29th and 30th. Do those work for the applicant?
Yes, those work for the applicant. I can't speak for Jim though.
Mr. Casino?
Yes. Well, it works fine for me. Time Tom is the one who knows about his witness availability, expert witnesses.
Give another week to go there. Mr. Cannell, is the county okay with those dates?
I believe so, Your Honor, yes.
All right, are the appellants available on the July 29th and 30th?
Ms. Cockamp?
Yes.
Oh, I'm sorry. I apologize. I meant to say Ms. Calkins. Do you have
Yes, I'm available.
So am I.
Wonderful. So I am going to issue an order. We're going to continue this hearing to begin on July 29th and conclude on July 30th. As I indicated before, my order will indicate that there's outside of the motion that we're going to talk about, that there's no new briefing on the SEPA or CUP issues. There are no new witnesses that will be allowed. There's no new expert witnesses or expert opinions, except as may be in Sir rebuttal. But I think that those opinions are still going to be consistent with what they've already stated. There's not going to be any more public written comment. The testimony from the public on the second day of the hearing will still be limited to 3 minutes apiece. The times for presentation will remain the same, with the understanding that if we do have significant expert witness reports out there, I guess I would just ask the parties to be to consider, just not having your experts just repeat what they've already stated in their reports, because those are already out there. We already have a long hearing, 2 days ahead of us, and so I'm hopeful that we can streamline the expert witness presentation and cross-examination, the agreements between the parties about that's already been reached about how cross-examination is going to be handled as far as their presentation time. That will continue on as well. So I think I've covered everything that I wanted to cover. Is there anything from the applicants at this point?
Well, one point of clarification, Mr. Kotkamp, on public hearing testimony. In your pre-hearing order, you stated that people could file written declarations or comments, either for or against, but they would not be allowed to speak their 3-minute speaking time in the hearing. The appellants have filed a number of declarations of opponents, their clients. Do I understand correctly that that then means that they will not be allowed to testify or speak at the public hearing?
When we get to that point, Mr. Cassina, how I'm going to handle this is I'm going to ask people that they're not going to be allowed to simply read their statements or their previous submissions. If they have something new that they want to add, they'll be able to do that. Regarding the clients of the appellants, I'm assuming that those would be presented during their time periods, both for the CUP hearing and for the SEPA hearing, if they're going to call these people as witnesses. But I'm not going to require. I don't want to get into the details of who's a member of this organization and who's not a member of this organization. So if somebody in the hearing wants to testify for their 3 minutes in the public portion of the hearing, for the CUP hearing, I will allow that, but I will ask them not to simply read their statement into the record. It's already in there. Does that make sense? Maybe
I
not.
suppose so.
Well, I think it makes sense, because the Friends of the Columbia Gorge, I don't know who the members are, and I don't know who the attorneys are representing. They're representing the organization and the members, but I'm not going to go through and ask everybody if they're a member of this organization or not, and then not allow them to testify. 3 minutes is not a great amount of time, and they've already been allowed time to submit their written comments. So that's how I will proceed on that.
So Mr. Kotkamp, this is Tom McDonald again. So in your order, you'll also provide the date when the appellants have to provide notice as to who they're going to be calling in terms of expert witnesses?
Yes, I will set that date. I don't know when that's going to be right now, but it's for the appellant and the applicant. So you're on the same field of that. If you're going to call somebody to testify, so that there's notice on both sides that these are the experts that are going to testify live, so that cross-examination can be prepared.
Okay, thank you.
Okay, is there anything further from the applicant?
This is Tom McDonald. Nothing for me, Your Honor. Jim?
Okay, all right.
Nothing further.
All right, is there anything further from the appellants, Mr. Telegen or Ms. Calkins?
None for me.
Sorry, none for me.
All right, thank you very much. Anything further from the county, Mr. Cannell?
Yes, Your Honor, we renew our motion for sanctions for late filing at a minimum should cover the cost of re-advertising the hearings, which the county is required to do.
Okay, well, I'm not going to award sanctions at this point. I haven't had any briefing on that. I don't know that that's something that I have the authority to do. I will state that I understand that there will be costs associated with this new hearing, and who those should be charged to. I'm not in a position right now to be able to make a ruling on that, if I even have the authority to do so. If there is any we're going to have that motion hearing on the 14th, and if in their response the county wants to make that request and demonstrate that the hearing examiner has the authority to award sanctions, I just don't know that I do. I've never awarded monetary sanctions before. I don't think that there's anybody in my other jurisdictions that have said that I have the authority to award monetary penalties, unless it's a code violation matter. So, but I'll entertain the request, I guess, is the best I can.
Thank you, Your Honor.
All right, thank you. Forgot where I was. Nope, and nothing further from the appellants. Okay, so I'll have an order issued hopefully by the end of the day today to send out to everybody. But again, those dates, the motion hearing is going to be, on July 14th. The applicants and county's responses by July 7th, and any reply by July 12th. That's where we'll get started on, and then the hearings will be on the 29th and the 30th. Okay? All right. There's nothing more to discuss at this point, so I'm now going to adjourn this June 17th hearing, continued, as I indicated, to begin on July 29, 2021. All right.
Mr. Cockamp, I
Yes.
apologize, late question. Will you be providing a date if the applicant is going to be filing declarations on any of its lay witnesses? Will you be providing a date when those have to be filed?
Yeah, I think for everybody that's a reasonable request. So if once I do have my order issued, if we need to discuss things further, then any party can make that request, but that's how we're going to proceed at this point. Okay. All right. Thank you all very much. I wish we were having a nice long hearing today, but we will take this matter up as I've indicated before. Thank you very much. This meeting is adjourned.
Thank you.
Thank you.